The public's interest in seeing what happened here is substantial. This is a trust that controls a very important function in our democracy before the state, largely in this country. And that public interest here isn't de minimis. It's gargantuan. And the amount of evidence that should take to outweigh that should be substantial. It shouldn't just be referring to in the statute. It says, though, such documents are confidential under law. And this is really the precise issue that we faced in the Falcone case, where we had statutes governing family law matters that said that certain proceedings and documents were sealed as a matter of law. And the court flatly concluded in that case, no. The Constitution applies in every case.
Abundant case law that says the press has no greater rights than the federal law. What concerns me here is that how can the public and the press in this instance be entitled to a copy of the trust when beneficiaries picked under either existing case law? Your Honor raised, I think, a really good point when ruling on the motion regarding attorney-client privilege. Had we known that this case was going to be open, it is very likely that we would have submitted as evidence, as filed exhibits, redacted copies of the trust. Very possible. As I said, Your Honor, this trust still contains an asset. This particular provision could affect how that asset is ultimately sold.
There are circumstances where these documents can be filled, especially by the court. And the question that we're really struggling with, leaving aside the fact that in certain cases under the federal law, in certain instances, trust documents may be kept private. Again, the burden is on your client, Mr. Levesque. Specifically, what information in this trust, could be misused, could be put to an improper purpose. Having reviewed the trust, I see nothing in it that's particularly salacious. That's not finding, just an observation. Are there specific categories of information that the court should protect from public disclosure? I think that's the best way to phrase that. I know this much: the court is going to unseal and unredact those portions of this trust that are referenced in the findings of fact, because the public has a right to see that the court makes a decision. That is the right the public has